All right, so our next panel is on mapping AI governance requirements to technical controls, and it will be moderated by Rafae. Rafae, I think, is like a unicorn, and I say that because he's both a CISO and a privacy attorney, and there's not that many people that are CISOs and privacy attorneys as well. He's currently serving as both privacy counsel and a CISO at Tilia, a payment platform for digital economies. And he's played that role, actually, that dual role in many startups. He's also the founder at ClaritasGRC AI. We've been talking about agentic AI a lot, and his startup is using that. So it's Shruti's startup over there, Zanya, she's going to be on the panel next. Claritas it's a legal consulting platform focused on AI governance and data protection. Previously, he has worked at companies like IBM, Oracle, Accenture, PwC, and he has 3 granted US patents. And he has also served for 10 years as an adjunct professor of computer engineering in Santa Clara University. This man just never sleeps. I think he's an AI right here. With his dual focus in information security and as a privacy attorney, Rafae, I think you are the perfect person to moderate this panel. Everyone, Rafae.
Thanks, Tilia. Thanks for that kind introduction. I think when you see the other people on the panel, you forget about me. So let's just get right in. So may I request Mark, Vasudha, and Linsey to please join me here. So today's topic is, as you heard, mapping EU AI Act requirements to technical controls. Now, why this topic, right? We have so much out there already on AI governance, right? Why do we need to assemble here again? And I think the answer is that while there's a lot of discussion on requirements and obligations of AI governance, there's really very little guidance out there about practical hands-on approach that organizations can just take away today. Think of like off-the-shelf or, to-go guidance that how would you translate these requirements into actionable controls without having to spend too much time and money along the way. So I think the fact that all of you are here is a testament to that there is this need for more guidance along these lines, which I think this session is going to provide, right? We're going to address that gap and be able to hope that you leave here with a checklist on how to implement some of these responsible innovation practices. We also have a case study today on how to apply our approach to enterprise applications. But before that, let's do another poll to kind of understand a little bit from the perspective of this panel. What best describes your role in relation to AI? For example, how many of you are working in AI from a legal and compliance perspective? Okay. How about technical, like an ML engineer or a data scientist? Product strategy? Academic or research? And who did I miss? What are you working on?
Plain old security.
Plain old security. Okay. From an engineering perspective or legal perspective?
It'll lead to legal if it's bad engineering. So, yeah. Yes.
All right.
Yeah.
I'll do both. Okay, so without further ado, let's get into the panel. We have on the panel today Mark Weber. Mark is the U.S. managing partner at FieldΦisher, where he oversees the United States operations. He's an English lawyer, so I guess we can call you a barrister, Mark?
Solicitor.
Solicitor. Yeah. Working full-time in Silicon Valley for over 16 years now?
Yeah.
And with a wealth of experience working alongside the world's leading tech companies, he consistently finds innovative solutions to complex legal challenges. His primary role as a lawyer is to facilitate the process of international expansion, compliance, and sales. Welcome, Mark, to the panel. Next, we have Linsey Krolik. Linsey is an assistant clinical professor at Santa Clara University School of Law, where she teaches classes and clinics in privacy law, startup law, and technology law. She's the Director of Entrepreneur Law Clinic, the Director of Tech Edge JD Program, and co-supervisor of the Privacy Law Certificate. Professor Krolik has been an attorney advising companies of all stages, from startups to medium to large global companies, for over 20 years, and has worked in-house for PayPal, ARM, Bill, and Palm. Wow, Palm. I remember their office in Sunnyvale, California. Quite an iconic Silicon Valley story. And she also has law practice focused mainly on privacy law and AI governance. Welcome, Linsey, to the panel. And next we have Vasudha Hegde. She is a senior privacy program manager and leads AI ML governance and technical product privacy development at Doordash. Previously at TikTok, she led the implementation of in-house privacy tooling for vendor privacy assessments, privacy incident response, and the orchestration of data subject rights for users and employees. Her interests include responsible AI, technical privacy, and data governance. Privacy incidents and TikTok, who would have thought it would go together? Welcome, Vasudha, to the panel. All right, we'll get started with a quick elevator pitch from each of you with what you would want the audience to take away from today. So we'd start with you, Mark.
Okay. Thank you, Rafae. So we've already talked or heard people talk about this balance between innovation and the new technologies. And I think this is one of the next kind of pivotal moments with AI where there's a lot of businesses wrestling with adoption. We've got to get it, we've got to have it, we've got to use it, and this practicality of how are we going to get it, how are we going to have it. And a lot of businesses getting that balance wrong. Some are missing the mark by doing absolutely nothing, and others are over-engineering their assessments and their evaluations to the point they're beginning to deny their businesses any access to some technology that they could have in their business. So I think striking the right balance is absolutely key, and picking out and working out how you can strike that balance in the right situation. And a lot of that comes back to, we're talking about mapping to technical controls. It's very easy to throw out, oh, we've got the NIST RMF framework. We've already heard that mentioned, but what am I going to cherry pick from that? How am I going to use that and work through that? Now, I sit in a world where I'm effectively a data lawyer. Data's the core of a lot of this. There's a world where we're beginning to see some AI law too, and we'll go in to talk about a bit about that AI law. For most businesses, it's not AI law, it's core, contract, confidentiality, IP, and those existing data laws. There's plenty to trip us up on that road to adoption of AI that's already in the world of existing law. Most of the things we'll talk about, I suspect, will come back to accountability. How can I show what I'm doing? How can I come back to the table? There's a lot of people doing audit in this room, a lot of people who have assessed risks. With the speed of innovation, we're seeing some businesses with maybe one or two AI models struggling to really map and work themselves into a situation where they can show what they've done. What if there was a McKinsey study that I read a few weeks ago saying within 2 years the average worker will touch on 60 AI models a week? If you can't get it right for one or two adoptions, how are you going to work with 60 or 120 AI models in your business? So making it simple and understanding what you're doing and getting a repeatable process is really key. That repeatable process comes, and I'll come back to this, is understanding what kind of AI adoption you're working through, or for some businesses, what kind of AI am I developing and putting out there? And I work more with vendors than I work with the purchasers of AI. But having that narrative and understanding that, and then working out how you can bring in controls and bring in existing processes to get yourself ready for that adoption is, I think, where we'll head. And I think having a system and having something written down is key. Because if you don't write it down now, you're in trouble later, and that'll be my biggest takeaway from today. So, yeah.
Well said. So I love that we teed this conversation up with, asking what frameworks are out there. So we'll talk a little bit do some compare and contrast about some of the frameworks. There are more. And so I think understanding that we can map at a high level and give you a starting checklist, and then it really is a use case by use case basis. But hopefully we'll give you some good practical takeaways in the starting checklist on how to get started.
I just want to add to everything Martin said here, just saying that I think if the audience here can walk away with the feeling that compliance is not going to add like friction, or it's not going to add, it's not going to block or provide a bottleneck to innovation, that is our end goal here, and we'll give you practical guidance on how we can enable that and how we can streamline, all of the reviews that happen, all of the assessments that happen, everything that we have to do in terms of compliance, be it because there are regulatory requirements that are coming up, or because your organization suddenly decided to comply with a certain framework and didn't ask you about it. But I think that's our end goal, and I will share what I've seen, common points of friction are in an organization when we're trying to balance innovation with compliance, and then what has worked for me, at least in navigating those sticky scenarios. So that's what we're talking about today.
Awesome. Well, that does look like a packed agenda, so we'll definitely get right in. So we'll start, Mark, with you. We'll start with the legal requirements, which is, the why of AI governance. Really, where should an organization start, right? We know that compliance requirements under the EU AI Act vary in terms of scope, the risk categories. So in your practice, what guidance do you provide to help your clients map these requirements to controls? And more importantly, how should an organization inform its risk posture, right? Is there a shift happening away from AI safety more towards AI innovation, right? Like there have been signals from, Europe and other countries that, hey, we need to get past some of these obstacles and get innovating quickly. Certainly the winds in the US, right, have been blowing in that direction. So what kind of enforcement trends can we expect in the future?
So there's a lot there. Let's talk, we mentioned something called the EU AI Act, new law around AI, and I think I sit advising businesses on what might happen to them if they trade in the UK or they trade in Europe, or they touch on the UK or Europe. The EU AI Act comes up a lot because I'm doing AI, there is an AI Act, I must be caught by that, right? Actually, the EU AI Act catches about 10% of AI that's on the market today. So if you're caught, it's significant, and it will provide a really useful framework and help you get from A to B, because it's going to bite and give you a set of rules to live by. If you're not caught, you're sort of left in, I've got to make things up and bring myself in the right direction by making up my own rules and my own framework and drawing upon that. And the EU tried to be a thought leader in AI and rushed some legislation. And to be honest, it's a little bit messy, to say the least. In fact, it could well be scaled back. We wait to see. A lot of it's not in play yet. We're phasing it in. There are some rules, and it's a risk-based approach. The EU's basically said, if I put a toy on the market in the EU, I hope the eye's not going to fall off and choke a child, and I hope that the leg's not going to fall off and break. There's some general standards around product safety that you would expect if you buy a toy and put that in front of a child. In the same way, it puts some general frameworks around the way, if you put AI on the market, we have some expectations on that. And the EU's approach has very much been a product safety approach. So, Rafae, if you kind of tog us on to the next stage, there's some things they've said in the world of AI, you're simply not going to do that. That's prohibited. You can't put that on the market. An example is social scoring in real time. Some of you might have seen that Black Mirror episode, which is out there, where someone's trying to rent a car and go and see their friends for the weekend. That's social scoring in real time, and that's worth a look at. We can't do that in the EU. There are certain things that are blanket prohibited. That's probably good news. Then the next tier down, there are some things which are high risk. If they're high risk, we're going to find we've got to do an awful lot before we deploy that AI, before we put it onto the market. This is the 10% kind of impact that I'm talking about. And we'll talk a little bit more in a while about how you're caught. But if you are within that 10%, you have to essentially go through your own audit, your own conformity assessment, work through some rules, and before you put that AI on the market, you and or a third party needs to say, yes, that's good, we can tick that box. Clue, that's not going to be a quick process. That could be 6 months to 9 months of effort before you can launch that product. In the EU, if you're a consumer using that AI, or if you're a hospital using that AI, you get some assurance from the fact it was high risk, it's gone through that process, it's gone through that level of conformity assessment, and I can use it. And then effectively, I can probably use that safely. So some of that responsibility for AI use has actually been put onto the provider of that AI. And there are different rules, whether it's a LLM and general purpose AI use, or it's other kind of use, and we can't really get into that detail at this point. But no, one of the key things to be asking yourself is, am I in that high risk category? And then you get other lower risks around minimal use cases. Essentially, I need to be transparent about the fact I'm using AI. I need to be clear how this AI was built. But it's a very, very soft regulation for that other 90%. So that other 90%, probably the majority of the B2B SaaS sitting out here in Silicon Valley, they're relatively unregulated by the EU. So instead you have to start thinking about other things. And I've got a diagram on here because where I want you to start thinking about is training data. What data is going in? How am I responsible for that? Was I even responsible for that? And then if I'm just using an AI model, what's the input data? We talked, heard Salesforce talking about, we don't hold, we don't retain their data. Well, there's data going in, data coming out. How do I use that? So there's the in, out, there's the shake it all about. But you've got to think about putting policy and guardrails around what's going in, how I'm using it, and where it's coming out. That's a very simplistic statement, but that's where we get into what contract says, that's where we get into what IP law says, that's where we look at the general data laws and things like the GDPR or the Californian CCPA and other rules around that. But most importantly, and this is my biggest takeaway from this, is what you're going to do with your AI depends on how you're using your AI. Are you building your own AI, effectively training it? If you're training that AI, you're responsible for that input, that training data going in, you're responsible for that AI model and potentially how it's deployed. The majority of businesses out there are actually going to be licensing in some AI, a completely different thing. That becomes a supply chain issue. Have I asked the right questions of the party that has trained that AI and given it to me? And then there's also that's something in between, and also saw that touched on in this first session. Am I going to bring an LLM and then do some of my own training? Is it going to be fine-tuned on my data? Am I going to use that LLM in a straightforward manner without doing any kind of fine-tuning? If I'm going to be just bringing in an LLM and using it, maybe integrating it with my own system and then putting it on the market, again, it's a supply chain issue. I can rely to some extent on what that provider of the AI has done. I can protect myself by choosing the right model. We've heard the joke. Is it DeepSeek? Is it something I trust? We've got some supply, some selection of the model that comes in. Or if I'm doing fine-tuning, did I buy the right model? Have I got the rights to fine-tune? And what about the responsibilities I have in relation to the data that kind of goes through and pushes through? And that's where we'll start to look at those frameworks. But that's also where, if you draw upon one of these frameworks, if I'm buying it in and it's a supply chain issue, is a very different framework application to the model where I'm essentially training my own AI model and pushing that out. And that's what I'll kind of come back to and talk to. But those flavors and the responsibilities that you'll get under the law are going to really matter. And if you don't understand that for every single AI instance you're using, some organizations may have trained some, they may have purchased some, and they may be doing some fine tuning, understanding, segmenting against those different AI models and having a way to deal with that and a way to categorize and look at this is my more risky activity, this is my less risky activity, this is where I trust in a provider, this is where I really don't and I have to do my own thing. Having that sort of system within your organization as you scale up and become more mature is absolutely essential. So we'll head there more, but let's hear some other introductions from some other parties.
So sort of, Mark, a distinction that I think you were trying to highlight there is that even if you were originally not in a high-risk category, but you took a general purpose AI and tweaked with it,
you could make it high risk by what you're doing with it, but that's understanding the use case, and that's understanding potentially your policy would say, well, don't use it for this, and also your contract might say from the general provider, yeah, don't use it for this because I haven't put it on the market for these purposes. In the same way, you buy software today and it says, don't use it to run an emergency services system. We'll find AI that says, bring this in, don't use it to do high risk, understanding where those borders will come. And I work with a lot of business that integrate AI, put it within their own AI system, B2B, and then push it out on the downstream. And how that works is becoming really quite difficult and probably one of the more technical challenges. What you've got to work out is what am I buying, what am I using, and how do I trust it? And it really is a trust equation at that point. So, yeah.
And so before we move on, another polling question for the audience, just to kind of understand how should we position the rest of the presentation. Has your organization started integrating the EU AI Act requirements into your existing risk management or quality assurance processes? So option 1, integrated and operationalized. Option 2, in progress, alignment is underway. Option 3, planning stage, assessing how to align. Option 4, not yet, still trying to understand where to begin. All right. No pressure, Linsey, but we're going to come to you for that. So what steps should organizations take to ensure their readiness for compliance with the applicable AI governance obligations? And if your organization is already compliant with GDPR and let's say certifications such as ISO 27001, etc., how much additional scope beyond that does AI governance implementation really entail?
Well, this is a slide that I'm going to ask you to go back one more, but existing frameworks, as you can tell, are kind of just a small slice of the pie. So, but how would we get started? Here is one version of a roadmap, right? So you might see different versions of this, but how you can sort of start to get your arms around this, map your use cases. Mark mentioned this, and this is something that is fundamental, foundational. It's the same thing we saw with compliance with GDPR, for instance, as companies were scaling up their data governance programs. Map your data. This is similar. This is map your AI systems and the use cases, right? And is it a model or that you're developing, or are you getting a model from somewhere else and implementing it, and are you fine tuning it? All the questions that Mark just raised. And then you really have to stand up more of a governance structure. So you may have some existing frameworks. Hopefully you do already in place for data governance, security, even ethics potentially, but these all have to come together in a somewhat different way. So thinking about who is responsible, who's on the small team, and then back to that map, you need to think about what human is going to be responsible for the outcomes of each AI use case or model. These existing frameworks are great to get started, and there are more things to do for AI governance. So things that were mentioned, I think by previous comments, hallucination, bias, but even just model level accountability, robustness is slightly different. And then you have ethics and sort of broader societal concerns to think about too. And then risk assessments, or sometimes impact assessments. You might have DPIAs, data impact, data privacy impact assessments, or that you might call them different things. You might have a product review process. This is great. More to do for AI, because you really have to understand the risks. As Mark mentioned, you have to understand where you're falling on the risk levels for the EU AI Act, for instance. But even if you're not caught, by that, you at least have to have a sense of where you're at. And then just really kind of thinking about your documentation as a foundation for customer trust. So embracing that process, hopefully getting you more towards that innovation that we've been talking about. So just a small slice, it's privacy and security, so more to do. And the next couple of slides, and I hope we'll circulate these slides to attendees, but just to get you oriented, there are different frameworks. There are more frameworks that are on the slide. The NIST AI RMF was mentioned. That's not on these slides, right? So just you can orient yourself in terms of what the focus is for these frameworks, because they're different. And some key principles for each of them. Some of them might have some overlap, but we've got some different ones appearing, especially on these last two here, the ISO 42001, which is around AI-specific risks, and the EU AI Act. And then on the next slide, there's a little bit, we kind of get into some more of the meat here. What are the differences between these things? And so as you can see, when you're looking at the AI governance pieces, you're looking at more mandated cross-functional governance. So we mentioned, getting legal and security and product and ethics in the room, and probably more. Thinking about a broad set of stakeholders is really important. And then on the documentation side, having that documentation, writing it down, understanding where things are originating, but also that testing and monitoring that was mentioned earlier is super important here. And then the ethics piece is just, we can get into a very philosophical conversation very quickly here, but making sure that that's a part of your governance process to ask the question, what happens when things go wrong here? So to give you a little bit of a starting checklist, again, this is like one more level down. Here are some things that you could do to get started, and this kind of, you could look at these as kind of actions to take based on each of those steps that we talked about. So doing your mapping, you might have a spreadsheet, or you might have a tool to do this. The governance roles and responsibilities, making sure that you have the team in place, and also the individual people that will be accountable. Risk assessments, look at what you have already, what can you leverage, and what might you be able to build onto that. In my own work, I've helped clients to develop sort of a level 1 questionnaire with some simple questions that maybe lead to then a level 2 questionnaire, because maybe not everything needs a super deep dive, but you need to understand, some at least gating information before you get started. And then just making sure that your documentation at every step of the AI development lifecycle has a checklist for what you need to do, and then asking that question about ethics and about what could go wrong for a wide variety of stakeholders.
Well, that's a pretty comprehensive approach, right? As you can see, right? So we promised you a checklist. Here's your checklist. We're done, right? Okay. Well, very rarely, right? You pass a checklist around and things get done. That tell me if you've lived in that world. So here's a question: what is your biggest challenge? So assuming you have the checklist and you're passing it around and people are kind of coming back to you for like additional guidance, what is your biggest challenge in mapping these checklist requirements to what you need to do with it, which is technical implementation? Option 1, translating the abstract legal terms into actionable controls. Tell me if you ever faced that. Okay, I'll try another one. Understanding how to document compliance, like technical documentation, logs. Maybe the answer is all of the above. We'll see. Option 3, list risk classification and systems scoping across a complex portfolio. Cross-functional collaboration between legal, technical, and business teams. They always work really nicely together, right? Or lack of clear industry standards or guidance. Well, this is an industry standard, but we'll see if there's lack of clear guidance there or not in the next panel, right, Vinita? Because we have some experts to talk about that. But right now, let's focus on implementation. So, Vasudha, we'll come to you for that. Tell us, how should organizations prepare, right? What do they do with this checklist? How do they run with it? How do they select the controls that are appropriate for the applicable obligations? And also, from a practical perspective, how do you evaluate the trade-offs when balancing innovation and compliance? What are some of the common points of friction that you have observed when working with product and engineering teams, and how do you address them?
Is it okay if I stand up? Just this. I don't want to keep my back or something. Okay, so yeah, great question. How do we balance innovation with compliance, essentially? From my past experience, I've realized that breaking it down into these three pretty broad buckets is one way to go about it. So I thought I would share that with you. The first one is looking at it through the privacy risk and response lens from the incident response perspective, but also trying to anticipate what can go wrong, just trying to understand, okay, what is the likelihood of everything breaking down, everything going wrong, what are the things that can go wrong, and making a log of it, and then seeing, okay, how are you going to respond when something like that happens. And Prashant, who spoke earlier, said that it's a new field. It's an excellent point. It's a new field. There's always things that can go wrong that you haven't anticipated. What do you do when that happens? You still need to deal with it, but you also need to keep that in mind for your future incident response. And then evaluating whether you're detecting incidents well, evaluating whether you're ready to respond to them. And then once you know what your possible risks are in terms of incidents that can happen, weighing your business value against your risk or your how you're prioritizing that risk. If you think that it's high risk, it's something that can really go wrong, and you want to do something about it, then you develop a compensating control based on your risk prioritization. And again, this is a decision that an organization has to take for themselves. You could be a really risk-forward organization and say that, okay, a small incident like this is not going to harm me too much, and be like, okay, I'm not going to waste time and resources and trying to develop a compensating control for something that I feel is a low risk. Another organization might find at high risk. So really determining what your risk threshold is, really determining what, as an organization, what you feel about, doing about all of these kinds of risks is really up to you. The second bucket I was going to think about was from a vendor risk steering perspective. Again, the common theme to all of this is risk, essentially. You're determining what your risk is in all of these different buckets. And then trying to streamline all of your risk assessments or all of the questionnaires and everything that comes from all of the different teams. At an organization that's having a lot of different teams, there's like 5 security teams, there's a legal team, there's a privacy team, there's a GRC team. There are so many different teams that all have like a stake in the matter. They all want to know, what vendor are you contracting with? What kind of risk are we adding to our environment by contracting with this vendor? And the answer to that is not sending, 5 different questionnaires to a vendor and having them answer all of that. That could be a lot of redundancy. But streamlining all of this process, and stop overloading, your low-risk engagements. If it's a proof of concept engagement, if it's, you're just trying out a vendor, an ML team is trying out a vendor, they're trying to see if there's something that works for them. You're not sending real data to them yet, so why overload them with a really lengthy risk assessment process? So this is one way in which I feel like the privacy team or the compliance team doesn't really have to always add friction to it. They can always, help out and enable an engineering team or a product team to make decisions quicker, to understand, okay, we want to go with a certain vendor, we want to use something, a certain supplier for a certain reason, and I would like to get the privacy team on board with that. And then embedding privacy and security early. I think this is something that's time and time again said in privacy by design, and in terms of even product launches or deployment. Making sure that the privacy team, the legal team, the security team, they're all coming in quite early in the game, and not stopping at the last minute and saying that, okay, you haven't gone through certain checks. And then again, from a regulatory compliance perspective, I would say the other two, even though the first one is talking about incident response, this is the one that is actually responsive, or this is the one that's actually a reactive sort of bucket. The other two are more proactive, they're more anticipating what can go wrong or anticipating what risks are. But from a regulatory compliance perspective, you have a regulation, you have a law that's coming in, understanding what your compliance requirements are from it, and then developing your strategies around it. But I would say, even though there are regulations that are coming in, they are important, they are it is essential to deal with them. I would still say take a step back, focus on best practices rather than focusing on checkbox compliance. It's not always in the best interest to just focus on that one regulation. And I know someone from a company who started focusing on AD&P compliance, the California Automated Decision Making Guidelines, which had initially said that it might be coming into effect as early as 2025 or the second half of 2025. But now I think it's been pushed to 2027. And now what do they do with all of the assessments and everything that they've done? It goes stale. They have to. This is something that they have to do again when the draft regulations are prepared again and it's coming into compliance again. So that is something that they have to think about, focusing on best practices rather than focusing on compliance or checkbox compliance. And these are some of the common points of friction. Late involvement of privacy teams, lack of early engagement, I spoke about it already. Duplicate or fragmented review processes, which leads to confusion on product or business teams. It happens a lot. The security that's in the questionnaire, privacy that's in the questionnaire. We really have to centralize your risk assessments and all that. Privacy compliance is often seen as a blocker for product enablement, not an enabler for product deployment. So this is something, again, it's a mindset change. It's something that the privacy team has to champion across the organization, and how they're enabling teams to bring forward their product deployment and making sure that if there's a compliance requirement, we're only helping them build responsible AI. We're not helping them. We're not trying to stop them from developing responsible AI. We're not trying to stop them from innovation. And then next slide. And then poor visibility into systems or data use. Again, this is something that can be solved with standardized documentation from the get-go. Your privacy teams have to communicate, or legal team has to communicate with engineering or product to say, this is the kind of information we want to know about systems and the kind of data that you're using, so that when the time comes for compliance or when the time comes for proving compliance, we already have all of this information ready. And then, of course, incomplete or vaguely or incorrectly answered privacy questionnaires. This is again something that happens all the time. Can be sort of mitigated when you use streamlined questionnaires, you use streamlined assessment processes, and provide context-specific guidance on what are we trying to find out from all of this questionnaire. Yeah, I think that's a few points that I would share about my journey in navigating friction and the way I see friction.
Thanks, Vasudha. Definitely a lot to unpack here, right? In terms of how to actually put all of this into perspective, and then how to actually address some of these conflicts. So in the last very few minutes, we'd like to walk you through a use case, right? which is a RAG-based CDS system. What is RAG? It's Retrieval Augmented Generation. What is CDS? It is a Clinical Decision Support System. So imagine a clinical decision support system that retrieves patient data and collects relevant information, things like medical summaries, diagnostics, and it could produce medical summaries, it could make diagnostic and treatment decisions, and let's say it could make insurance eligibility decisions, right? Now imagine you're using an AI model. One mode is when you're integrating the model and you're updating it, right? And the other is that you're simply licensing that model. So we'll quickly walk you through the scenario here, which is that the considerations you have to keep in mind from a GDPR perspective, whether or not your scenario qualifies as automated decision making on a special category of data. So, Mark, would you think that healthcare data would fall under special category data at all?
Yeah, I think it would be fairly safe to say it would. So you'd be processing personal data which identifies somebody, but it would be in the category of health related. It relates to an individual, and therefore there would be under the GDPR, a prohibition on processing that data unless you had a lawful basis, and that lawful basis would typically be consent of that end data subject. So it would be a consent-based activity to use that sensitive data.
And how about the difference between the two use cases where one use case only produces medical summaries and another use case actually makes decisions about treatment or insurance?
So medical summary, you're still processing data within the context of that, so it would be consent-based for that. If it was making a decision about that individual, under the GDPR, there's a right not to have an automated decision taken on you by AI, or at least by an automated system, if it has a significant or legal effect on you. Probably not having a legal effect here, but it could be significant whether you're successfully diagnosed or you're not. So you'd be in a scenario there where it is automated decision making under the GDPR. Doesn't mean you can't do it, but you essentially have to probably work on the basis of a permission because it's sensitive data, but then also give the opportunity for the individual to opt out of that decision making and have a human make that decision instead if it was an entirely automated decision. So there's a bit of careful analysis around how that ADM works, that automated decision making, but essentially you're looking at two types of permission even before we've thought about AI rules that may be cut in there. So there's quite a lot of protection anyway, and you could argue we don't need any more law because the law's already serving us quite well. So.
Right, and Linsey, are we right that we might need DPIA if it's automated decision making?
Yeah, absolutely. So, now you're in risk assessment land, and, just to highlight the difference between the provider of the system, what they might need to do for a risk assessment, they might be thinking about, well, is there bias or discrimination in the way I've designed this system, right? Whereas the deployer, who is going to implement this system, might be thinking about, well, is the model making false positives or false negatives, and what's the impact of that? Because they're actually kind of on the ground implementing it, right?
So depending on deployer mode or integrator mode, you would have certain differentiations as well. Given that this is health, it's all going to be high risk for sure, but then if you are an integrator or provider, you would have those additional ethical obligations, but at the very bare minimum, everybody's going to have the transparency obligation. So this is just kind of like a very quick overview, right? Like, what are the considerations that you should be looking into? We are running out of time, so AI can't buy us more time, otherwise we would be here all day. So I do have to hand it over to Benita for the next panel, but before that, a huge round of applause for our experts.